Hey y'all, figured I'd give you a little different look, going with a little Ted Lasso look today. Today we're going to talk about standards of review. So obviously we're talking about appellate standard of review here. So obviously things happen in the trial court, right? Whether it's civil or criminal, a trial court is going to make decisions, and then essentially or eventually it's going to be appealed to an appellate court. Once it's appealed, the appellate court has to decide what standard of review that they will abide by in order to, give certain deference to the trial court. Does that make sense? So they have to give a certain amount of deference to the trial court unless certain reviews apply. And we'll talk about that first. If it's a matter of law, then it will be a de novo standard of review. DENOVO. You read that in your chapter. But essentially, there's not much deference that has to be given to the trial court at that point. So an appellate court can essentially look and make their own law. This is their time in de novo review that where they can make their own law. And appellate courts will do that. Now, I wouldn't say frequently, but they occasionally they will do that where they decide, look, this law, yeah, the trial court applied the right law, they did, but we're going to change that law because we feel like it's outdated. That may be a reason. Feel like it's unfair. That may be another reason. So essentially, they may take that opportunity to make new law under the de novo standard. So a trial judge's decision of purely a question of fact is going to be subject to a clearly erroneous standard. Okay. So essentially, a judge is left with definite and firm conviction that a mistake has been committed. That's the only way that you can overturn a clearly erroneous standard. So if the judge is acting arbitrarily or unreasonable, then that is a time where the appellate court can apply the clearly erroneous standard and reverse or remand the trial court's decision. There's a lot of policy rationales, and those are talked about in your book. But essentially, a trial court is as a fact finder, right? They're the ones seeing the testimony, seeing the things happen on the stand, and reading the depositions, etc. But most importantly, they're seeing how these witnesses testify, and so they are in the best possible posture to decide certain things, and so that's why there's a difference given from the appellate court to the trial court. The other thing is, if everything was appealed all the time and and every losing party got the appellate court to give a fresh look at it, the docket would be completely full. It's just fair, right? The trial court heard everything. They saw everything happen. And so it's fair that we should give deference to the trial court in those situations if it's a matter of fact. And there's also resources. The courts don't have enough resources. The appellate docket would be completely full all the time if everything was a de novo review, for example. Now, if a jury reaches a verdict, it's a competent evidence standard. As long as they followed the correct jury instructions, then it's usually upheld. Now, if it's some kind of a rational thing, or if it's, no reasonable juror could have ever decided this, then, it may be reversed on a jury verdict. So, as far as mixed questions of law and fact, if there's a disagreement on the way the court applied the law to the facts, when I'm saying the trial court, if there is a disagreement on how the trial court applied the law to the facts, then you got a mixed question of law and fact. And the majority of those are de novo review. If they are involving constitutional law, they're usually always de novo review. If they involve negligence, now it's going to be clearly erroneous. And an example of one of those is like a motion to suppress. If a motion to suppress evidence, let's say based on the Fourth Amendment, you've heard me talk about traffic stops. If there's a motion to suppress evidence based on the Fourth Amendment, it's usually going to be a mixed question of fact and law. The court is going to be evaluating witnesses and evaluating the law, and let's say the court denies that motion to suppress. So if they deny a motion to suppress, then after the case is over, the defendant will usually, if the defendant is unsuccessful or pleads guilty or is convicted, the defendant will appeal that. And that appeal right there will be de novo review. Okay? So, because it is a mixed question of law and fact involving constitutional law, the Fourth Amendment, right? And it's a mixed question because the court is looking at witnesses like from the trooper, the defendant, etc., and is also applying Fourth Amendment law to that traffic stop. So that's an example there. So the trial court just must not act unreasonably or arbitrarily, and an appellate court's going to look at that to make sure that that does not happen. Judges have a lot of discretion. Trial court judges. If you're in a trial, there's I'm gonna say sometimes 30 decisions made by the judge just off the cuff. There may be an objection to hearsay. There may be objection to leading question. There may be objection to relevancy. There may be 403 prejudice. A lot of evidentiary issues that you could have, and the judge is just going to not even think about it, and the judge, he or she, may just say denied or sustained. So a court is given that discretion, right? They need that discretion because they don't need to be worrying and stewing over every single thing that comes up. And so that's kind of why we have what's called an abuse of discretion standard. This applies a good bit if there's a motion to sever. Sometimes that is within a court's discretion, and the court will decide on whether to sever out a defendant. That's within the court's discretion, and so if the court abuses that discretion, then it can be appealed, and the appellate court can decide that no, this court abused its discretion, it acted unreasonably or arbitrarily, and then essentially reverse or remand. But again, if the trial court was not acting in their discretion, in one of those discretionary times, was not acting unreasonable or arbitrary, then the appellate court must affirm. Okay, so to find standards of review, the best thing to do is, and you can do this with your brief, but the best thing to do is find a similar case. If you find a similar case as to yours, look at what standard, and you're going to be looking in the appellate court. So if it's Fifth Circuit, Fourth Circuit, whatever circuit, it doesn't even really matter, but you want to look in the same circuit where you are. So if it's a Fifth Circuit case, then you're going to want to look in the Fifth Circuit. Find a similar case from the Fifth Circuit. Find out what standard they apply. It's always at the first, right after the facts. They talk about the standard they're going to apply for each issue. So maybe a motion to sever issue, maybe a suppression issue. For each issue, they're going to list the statement of facts. Okay. And by the way, if there's a question on whether de novo review applies or abuse of discretion or clearly erroneous standard applies, if there's a question there, I usually just put both or all three or whatever. I will put in the alternative, I'll put here's the government submits that the de novo review standard applies. However, if the court finds that the clearly erroneous standard applies, this is my explanation. Does that make sense? So basically, you're giving the court an avenue to find both ways. All right, going to Scalia's principles. You can never waive jurisdiction. That was a good point he said, even if no parties raise it. I'll show you a case where that actually happened. And so I'm going to post that for you. It's United States v. Kevin Co., where neither party brought it up and the Fifth Circuit brought it up, and we were kind of like, whoops. So you never want to do that. And you always want to look for jurisdiction first. That can bite you. Know your judge. We have certain judges, when I go in for a change of plea hearing, that he or she does not want me to read word for word everything in the plea agreement. They want a summary. And so I give just a small summary of what's in there, okay? So there are other judges that want me to read every word, or they're not bothered by the time, they're not bothered when I read word for word. So, you got to know your judge. You always got to know your judge. Ask around, ask colleagues. You may want to read a couple of their opinions to see how they work. And the other thing Scalia talks about is don't be a blowhard. Like, don't pound if you're going to court a good bit, don't pound the table every single time you go to court. Even me as a prosecutor, I know that, there's certain times where maybe the United States Probation Service wants detention for a person, wants to detain a person pre-trial, and I'm just not that fired up about it, but I'll support them. Well, I'm not going to go up there and beat the table the whole time saying this person needs to be detained. I'm going to, I'm going to advocate for my case, but you're not going to say this is the worst defendant that's ever walked through your court, every single time. So pick and choose when you pick and choose those battles, because the judges will notice that, and you will lose credibility very quickly. Be certain that you're 1,000% accurate in anything you say in front of the court. Anything. If you don't know, just say, I don't know, Your Honor. I'll get back to you. I will brief that later. I will supplementally brief that. Whatever you do, don't fudge things. Don't say, yes, Your Honor, that is right. Even if it sounds like it's right and you don't know it's right, don't say it, because it will burn you. I've seen it happen, and I've seen people lose their bar license because of it. Always leave yourself a way out. So if you're asked, counselor, have you found a case where this applied, where the defendant's, let's say you're on the prosecution, where the defendant's case applied, you say something like, Your Honor, we have done a search and we can't find anything. But what you don't say is, you don't say, Your Honor, no case exists. I can tell you right now, no case exists, because, I promise you, after you say that, lo and behold, some case will pop up in a couple weeks, then you lose all credibility. Okay? So leave yourself a way out. Be civil if you're attacked. You're going to be attacked. You're going to be attacked when you're a lawyer. I promise you. You will be attacked by other lawyers. If you do, you got to maintain your composure. Do not go down that path, even if you're attacked, and even if your credibility is attacked. Be civil. Don't attack the defense. Don't attack the other attorney. Don't ever do it. Don't ever say that attorney's trying to mislead the court. I've seen it happen, even where I knew the attorney was misleading the court. When I was clerking, one attorney said the other attorney was misleading the court. The court did not want to hear any of that. Now, the court may have its own opinions about it, but they don't want to hear the other counsel saying something about, he's misleading you, Your Honor, misleading you, Your Honor. Don't do it, even if they are. Don't do it. The other thing that was a funny story Scalia was talking about is naming certain things in the case. This actually happened to me in a case where there was a sawed-off shotgun that the defendant had. I'm sorry, it was not sawed-off, but it was a double-barrel shotgun that the defendant had, and it was hanging on a wall right outside of his room. And it was an older shotgun. Well, the defense attorney kept calling it a wall hanger, acting like it was an antique. Well, it was indeed illegal for that defendant to possess that firearm. And we didn't like it being called a wall hanger, and we tried every which way to not call it a wall hanger. And by the end of the case, the judge was calling it a wall hanger. So just keep in mind, if you keep calling it something, and what I should have done is I should have called it the double barrel, or something to that effect. I didn't do it. And by the end of the case, it was called a wall hanger. Now, everything ended up working out in that case, but point being, it's important to frame things in certain ways. And I mean, again, the judge started calling it that. So if I just kept saying double barrel, the judge may have called it a double barrel by the end of the case, which sounds a lot better than wall hanger. But anyway, those are some points that Scalia brought up that were actually great points. And if you have any questions, please feel free to email me. Thank you.